Uh, I'm seeking your lordship intelligence to list this matter, my lord. My lord, in this is
Please for listing, please give it to the court master.
my lord.
We'll take care of it. IA for?
IA for extension of time for appearance.
Okay. Make it Friday.
Item 21 for judgment.
The impugned opinion is set aside. And the matter is remanded back to the learned tribunal for a fresh hearing and opinion in accordance with law. The petitioner is directed to appear before the tribunal on 29/9/2024 and await further instructions from the said learned tribunal. The petitioner is directed to appear before the Superintendent of Police Border Nagaon and to take bail. In the event the petitioner does not appear before the learned tribunal on or before 29/9/2024, it will be open to the learned tribunal to direct the Superintendent of Police to take the petitioner into custody in the interest of expeditious disposal of the proceeding. Within time, you have to take bail.
May I please, your lordship? My lord, I beg to mention for a listing of a custodial death matter, my lord, tomorrow, my lord.
Tomorrow, okay.
My lord.
Obliged.
You to the court master.
May I please, your lordship? My lord, I have two items before this honorable court today, my lord, item 7 and 8, my lord. So far as my lord, the item number 8 is concerned, my lord, I could not take preparation, my lord. I'm praying for adjournment of item number 8, my lord, for the day only.
Okay.
Item 7,
7 is also my case, my lord. I'll proceed in the case. Item 8, my lord.
you are seeking
Okay.
adjournment only for 8.
Yes, my lord.
Now, let the constitute both sides are represented. Okay. Deeply blood.
Wait, please, your lordship. So I have to mention for listing, I has been held for
Listing, give it to the court master.
correction of the order, my lord, tomorrow, my lord.
Give it to them. Let them. Fix it.
Your lordship, I have to mention item number 11, your lordship. I seek 2 weeks time to file IA for extension, your lordship.
What extension?
For time to appear before the SP.
No, 2000. This is a 2017 matter.
Yes, your lordship. Lordship, we are on
Now
18
again,
day.
you want 2 weeks time. No, we can't give that.
So 8 weeks time, 1 week.
No, you take 10 weeks. Why 1 week, 2 week? It's a 2017 matter. You take 10 weeks. But we are not adjourning the matter on that ground. That is not a ground for adjournment. No. That is refused.
Plus, sir.
My lord, one motion matter, my lord, may I pray?
I have
for
told you this time, this is the third time we are telling you. Please give it to the court master.
I have.
Prayers for listening, give it to the court master.
I'm sorry. Well, may I pray another matter? LCR has come, my lord. Some urgency is there, my lord. Court master.
That is refused. Now both your prayers are refused. Today we are not accepting your motion, prayer for listing. Today it is refused. Both of that will not be taken up.
My please, lordship. I beg to mention item 5 and 12. Due to personal difficulties, Ms. Sinu is unable to appear before this court day. Kindly adjourn the matter for the day.
12.
Yeah, 5 and 12.
Okay, both sides are represented. The prayer made by counsel for the petitioner. Okay.
Master, please.
Item 1 for motion.
before the other side. So we were supposed to file an affidavit, but because of certain clarifications, Lordship, we could not finalize the affidavit. And it is pending approval of the Honorable Chief Minister, who is holding the home charge. So I'm praying for 2 weeks
No,
time.
but in
to
a
file.
habeas corpus, you know the High
The
Court.
body has been already taken by them.
Huh?
Body has already
No,
been
no,
taken
that's
and
okay,
disposed
but-
of also.
Still in a habeas corpus, we have,
Then 1 week's time
Adults.
may be given, Lordship. Because the assembly also held, all these things could not complete the exercise. Only 1 week time, Lordship.
Yes, also on
Okay.
16. 16
16th,
or 17.
Advocate General,
Let it be on 19th, Lordship. Or 18th.
agree, what
Yes.
you, both of you
No
discuss.
difficulty.
If you want to,
Yes.
if you want to consult your
Senior,
senior from
I
Guwahati,
think he could not connect.
no, it's
Actually,
okay,
he wanted to appear before.
it's
launching.
okay. You can take it,
I can take his consent and I'll just
please.
verify.
Because 17th is the puja and all, Lordship, that is
that's
right.
okay, let me take
19th is
consent
the
because-
hearing day.
Wait for 2
Yes.
minutes, let her
I'll
take,
just take consent of. my
let her
senior.
take consent. It's only the question of date.
Lordship.
Ms. D. Ghosh, Learned Counsel for the petitioner is present. Mr. D. Saikel, an Advocate General, assisted by Mr. D. Nath, Senior Government Advocate. Prays for some more time to file affidavit in opposition in the matter. Mr. Prayer for adjournment is allowed. List on. Just wait for some time.
Yes, Lord.
I'll give you the-
Item 2 for orders.
May I please? My lord, dismiss this for my lord, restoration of my lord. The waiver, my lord, which was dismissed on for non-prosecution.
Pardon me? Please repeat again.
My lord, we have filed this case for restoration of WC number, my lord, 4864, which was dismissed, my lord, for non-prosecution on my lord, 12/6/2024, my lord.
What was the ground?
My lord,
Why
actually,
was it dismissed?
my lord, on that day, my lord, we were absent, my lord. Actually, we were in the court, but for time being, we went outside, my lord. And when we came back, my lord, the matter was dismissed.
Due to oversight.
2
Paragraph
days, my lord.
4. You see, the ground taken deserves, makes this matter deserve to be dismissed. The reason is, when we are on the bench. Or even when Honorable Justice Pathak is in bench. And a matter is dismissed for default. When the council comes back, we take it up. Your ground is that you went to the washroom, when you came back, the matter was dismissed. I don't think we have ever. There's anything on record to show that whenever such a prayer is made. For taking up the matter, any court in Guwahati, principal seat has refused this, such prayer.
Actually,
We don't know, you are taking a ground. That ground, we don't think it has ever happened in this court. At least in my experience, we don't have that. Hmm? Hmm. Let it come after a week. We are absolutely dissatisfied. This,
2 dates, Lordship. There may be other dates also, I remember, Lordship.
no, we are not on that, but you see,
Hasn't appeared, Lordship.
has it ever appeared? Has it ever happened there's a matter dismissed for default. After some time, the lawyer comes when we
no.
do not take it up. I don't think it is.
You should have made a
Like,
request.
in that court, it is very easy to please the court and, seek an
No, it's not a
apology.
question of
get it
that. It's not a question of one court or second court.
Don't be so discriminatory. It's there in all courts. The matter
is-
is dismissed,
I
you
was
come
there,
and request
Lordship.
the
That
court.
is why I said that court, because we are appearing in these matters every day for last so many years now.
Not only that court, all courts.
All courts, I think.
But
Because here, the
guys,
matter gets
Lordship,
dismissed on the same day, you make a request. It's taken up even before the order is
Actually,
signed.
my lord, what happened, my lord, after dismissing, my lord, the court, my lord, arised. I could not make the prayer, my lord, to recall the matter.
12-6 order, Lordship will kindly come
That's
to
right.
12-6
We are in
order
the month of
at
September.
page 14.
My lord, it hasn't filed my earlier, my lord, but it has been listed for several times, but it was not taken due to paucity of time. Well, on any terms and conditions, my lord.
Sorry.
Lordship, at page 14, the reasons also cited. No, no.
After 1 week.
Any date, my lord.
Item 3,
Because we would be dismissing it if we hear today. We are getting a chance. Yes, Ms. Ghosh. Advocate General may come.
18th Lordship.
18th.
18th.
No difficulty.
Lordship, one humble prayer on behalf of my senior. He has said if the matter can be made at Pathat because he has argued that.
Don't make that.
Okay, that I just, he told me just to press once. It's up to
Without the
Lordship.
affidavit, the
You
hearing.
see.
I understood, I
No,
understood,
No,
Lordship.
not that. What you call, let there be a practical demonstration.
Yes.
You see, keeping few matters part head has caused this. Declining of headline.
That's good. Lordship, I won't press for it. Amazing.
This is a lighter tone.
Yes, Lordship.
I have no objection if Lordship keeps it apart, but
Uh,
we have not filed the affidavit yet.
No, 18/9/2024. The affidavit shall be filed at least 2 days in advance.
We'll try to, by 16th evening, we'll give.
Oh, okay, 1 day in advance. With copy to the other side.
Highly applies.
deeply.
item 3,
It's a criminal appeal. The I was pending on medical grounds. As per the last order, a report was called for from the neurology department of GMCH. My lord, PP is not here.
Okay. Then please give a scroll for APP. Item number 3. Okay. Just wait for some time.
item 4,
My name is Abdul Aziz, my lord. Abdul Aziz and Abdul Aziz, my lord. And my father name is. My lord will find from page. Grandfather's name, my lord, starting from page number 25. Rahmatullah Munshi. Of the
What's
year
the name of your grandfather?
Rahmatullah. My father name is Suleiman Ali and Suleiman Sheikh, my lord. Grandfather name, my lord, will find from page number 25, my lord. Of
Rahmatullah.
Rahmatullah.
Which line?
Uh,
Page 25, which line is Rahmatullah?
Rahmatullah. Rahmatullah.
Page, line number, which paragraph?
25, my lord. Page 2.
We are there at 25. We are asking
One-
you the line number.
11113, my lord. Serial number.
So there is something wrong. There is also an order sheet that the page number indicated by you is not available. You are asked to correct it. You have not done it. If you don't do, we'll have to dismiss your matter. There is an order of 21/6/2023. Petitioner refers to the name of grandfather of petitioner at page 25. But page 25 of the writ petition is noticed to be a written statement and not a document containing the name of the grandfather. So even after 1 year, you have not neither read the order nor corrected it.
My sincere apology, my lord.
No. You see, we have granted the petitioner bail. That is the
One
difficulty.
last chance, my lord. Somehow I have not.
Okay.
Only one last chance, my lord. I definitely make necessary correction. My lord. In the paging, there's something wrong with the
Mr.
paging.
A.S. Tapadar, Learned Counsel for the petitioner, is directed to take note of the order dated 21/6/2023 and take remedial measures, failing which the interim protection to the petitioner would be revisited on the next date. So all the respondents are represented. List after 2 weeks.
Oh, I'm deeply obliged.
Item 6.
My name is Saifuddin, my lord. Page 24.
Where is the written statement?
Written statement, my lord, will find at page. Starting from page 16, my lord, 5 copies. Original, my lord, page 18, my lord.
Page
16 is the 5 copy, my lord.
Yes. Page.
Page WS page 16, man.
Yes. Please read.
The opposite party's name is enlisted in the voter list of 2011, 90 number Jomunamuk LSC, part number 44, house number 85, serial number 222, as Saifuddin, son of Ibrahim Ali, in the voter list of 2014, 19 Jomunamuk LSC, by part number 44, house number 85, serial number 217, as Saifuddin, late of Ibrahim Ali, son of late Ibrahim Ali. Paragraph 2. The opposite party's father name is enlisted in the voter list of 1966, 90 number Jomunamuk LSC, by part number 109, house number 25, serial number 97, as Ibrahim Ali, son of Haji Yaqub, in the voter list of 1970, 92 Jomunamuk LSC, by part number 109, house number 24, serial number 85, as Ibrahim Ali,
son of Haji Yaqub. The opposite party's actual name is Muhammad Saifuddin, but his name is wrongly recorded as Muhammad Saifuddin instead of Muhammad Saifuddin. That the case has filed against the OP falsely without any investigation, so the case is liable to be dismissed. That the opposite party is a bona fide citizen of India by birth, not foreigners, so the case is liable to dismiss and the prayer.
Where were you born? When were you born? How many members are there in your family?
This is not there in the WS, my lord. But my father's name, page 24, have a look, my lord.
24.
Page 24. My father's name is Ibrahim Ali of it is the voter list of 1970, my lord, of village Charlock, Jamuna Mukh, my lord. Ibrahim Ali, serial number 84, house number 24. And my lord, in the written statement, I have read, my lord, my father's name is Yaqub Ali. Then, my lord, page 26.
Who is Khatun Bibi? Page number 24.
In the WS, my lord, it's not there who is Khatun Bibi, but here, and reference can be drawn, my lord, here, the Pita Ibrahim, Alima Bibi, and Y. In the written statement, nothing of, it's not been written, my lord, who is Ibrahim, who is Khatun Bibi, my lord. And the same village, my lord, my father's name, Ibrahim Ali, continues in 1997, my lord, page 26.
Where is the first voter list?
My
Where your father's name appears?
My father's name appeared for the first time in the voter list, my lord, in the page 30, my lord. My name for the first time appeared along with my father, my lord. Page 30. Here it is only Saif is written, my lord. Village is same. Mohukuma same. Assembly constituency is same. Ibrahim Ali on top, my lord, 89. And my name is 97. Saif Ali, my Saif, only Saif, my lord. This is for the first time my name appeared, my lord.
Which page?
Page 30, my lord. It is continuing from page 24, my lord. My lord, I have shown is page 24, Ibrahim Ali and Yaqub. Page 26 again in serial number 249, Ibrahim Ali, same village, same Moza, same Thana, my lord. Page 26, Ibrahim Ali is my father. And then, my lord, page 28, same village, same MLA constituency, my lord, same Moza, Ibrahim Ali. And then my name, along with my father, appeared in page 30, my lord.
This is the serial number. 66.
You want to go through the records?
Not
It will- Where is this? We are trying to check up from your writ petition. Where is the document of you, your parents together? Any voter list?
Unfortunately, my lord, the exhibited document, nowhere it has come along with my family, my lord, except 89, my lord.
Except
89 voter list, page
1989 voter
page-
list.
page 30, my lord.
sixty-six, you have not enclosed.
Yeah, I have, my lord, this is NRC data, my lord will find it. Page
No, no,
30.
voters list.
Voter list, unfortunately, I haven't enclosed, my lord. Thereafter, my lord, as per the instruction of my client on 2016, the Yakub Ali got landed property in the same village, Charlock, my lord. Unfortunately, that was not exhibited.
But he has not disclosed who his family members are, when was he born.
I have read out, my lord, WS. This is what it is written, my lord, nothing else. But beside that part, my lord, not disclosing the family member, my lord.
No, you see, the tribunal has disbelieved your case because of the very simple reason. 1966, as per the NRC, your voter serial number is 39.
Yes, ma'am.
In 1966 voter list, which is Exhibit 1, the voter serial number is 97, therefore it doesn't match. And that is why when this annexure 1 is, Exhibit 1 is not annexed, we have to see the LCR.
The reason, my lord, of
So if the voter serial number is a mismatch, that means the document is unbelievable.
thereafter, my lord, there's 66.
No, if that goes, everything goes. That means in your village there are 2 Ibrahim Ali.
As per this document that I have annexed, my lord, here it's only one Ibrahim Ali.
No, but you see, 1989 document is a post 71 document. You have to link it with 71 document, and 71 document is 1966, which is a mismatch.
Page 20.
And there's no explanation in your written statement, no explanation in your evidence. And this is a major, but it's a major point on which the tribunal has dismissed it.
Page 24 can be looked into for a once, my lord. Ibrahim Ali, even this is the voter list of 1970, my lord. Same village, Moza Dominamo, condo number 109, my lord.
The house number keeps on changing.
House number is changing, my lord. Even in 66, my lord, page number 33, house number was 10104, my lord. House number,
But in
And
the
that-
absence of your disclosure of your family members, how we understand that whose voter this is, 1917 voter list, there's one Khatun Bibi. It's not there in 89. In 1970, there is one Alima Bibi.
yes, my lord. That,
And here in this 89, it is Almina.
that has been discussed by the Lionel Tribunal, my lord.
No, but
Because of-
without your stating the facts, how will you understand that your explanation is correct or not?
From the voter list of 1970, my lord, Almina Bibi, in column number 3, it's shown that husband, my lord, Ibrahim. So two wives comes in picture, my lord. Hmm. Even though, my lord, my respectful prayer will be, I have not enclosed the petition, my lord, probably it was not exhibited. I got the copy, my lord, in voter list 1966, the certified copy, my lord. Ibrahim Ali's name is there, Alpina Bibi is there, and Khatun Bibi is there, my lord. This is the voter list of 1966, which has been reflected in.
Unless you disclose in a written statement, how will you understand which voter list you are preparing and producing?
This is how WS has been written, my lord. I'm a poor man, my lord. I'm not aware why.
Mr. Sharma, please show us your, please send the LCR back.
Yes, Lord.
Just a moment.
You have to show the link.
Yeah,
That was
link, my lord, as far as 89 voter list concerned, for the first time along with my father appeared, my lord. In the same village, same LSC, my lord, there is no shifting. So,
'89 voter list. Where is your name?
page 30, my lord.
Page 30.
30, yes, my lord.
Review. Ibrahim Ali is your father.
Ibrahim Ali is my father, my lord.
Almina.
Almina, my lord, even though I have not disclosed in my written statement, but in the opinion, my lord, it's two wives of two mother, my lord. Almina is my mother, my lord.
So where is your name?
My name is 97, Saif.
90?
97, my lord.
97. Soif.
Saif.
Even in your affidavit, evidence on affidavit, you are not explained the difference in the name of your mother or the earlier voter list,
Family history is not mentioned, my lord.
then how can we help you?
But as far as this voter list is concerned, my lord, it is clearly going to demonstrate that my father is Ibrahim Ali, who was the citizen of India, my lord. Even his name appeared in the year 1966, continuously coming his name from 1966 to 1989.
No, there is no dispute that there is an Ibrahim Ali. Dispute is whether that Ibrahim Ali is your father or you are his son.
Yes, my lord, as far as these voter list
No, this voter list is one example.
and other than
The ordinarily, you would have explained who the other persons are, how many members of the family you have. Supposing in the, let us come to 89 voter list, you find Abdul Motin is there, who shows Ibrahim Ali is his father.
the way
Tina Bibi is there. Kulsuma Bibi is there. Abdul Mannan is there. Sahab is there. They must be your siblings.
there in the right column, my lord, the meeting all
No,
Ibrahim
no,
Ali.
in your affidavit, you don't say that they are your siblings. That is what my brother is pointing it out.
My lord, since I have not mentioned in my WS, my lord.
No, not even in your evidence.
In your
You're showing a document and you're not proving the contents.
Otherwise, my lord, by this voter list, my lord, it's
No,
clearly.
you know the principle, Mr. Tafadar. You know the principle of evidence. You have to prove the contents of a document.
Yes, my lord. That mistake, my lord, has done by my learned friend.
Evidence. Evidence. Evidence.
Examination.
Who is Ibrahim Ali?
Ibrahim Ali is my father.
You come to page 23.
Yes, sir. Yes, my lord.
He's in 70, his age is 54.
Yes, my lord.
Up to page 27. In 85, he's age is 45.
Yes. That age difference is there. Age difference is there.
Not difference. He's growing younger. Then you see in 89, he has become 72 years.
Two thousand 15. 2015.
Yes.
89 was not exhibited, Lordship. 89 was not exhibited. Just not before the FT, Lordship.
Tinta দিছিল tinta.
13. He's also from the other. 2015.
See, in the cross, you have stated your father expired in about 30 years back. In this cross was held on in the year 2015. So by that analogy, it must be around 85, 86, he must have expired. But 89, which you are relying on now, shows he's 72 years old, not expired, at least from the voters list. So
And there is a finding in the tribunal's order also, page 9A,
9,
expired 30 years ago.
30 years ago. And he
have you seen the cross, Mr. Sharma?
Not seen.
Cross examination.
I have not seen, Lordship.
Have a look.
Some medals. Some medals or awards for such a beautiful cross examination. Unless the state honors people like that, you will not get good people. Okay. You mentioned something. I think he is one of 5 cases.
Lordship, here he has stated that Lordship, মোৰ মা দুগৰাকী, প্ৰথমজনী বৰমা মাছম্মদ আলবিনা বিবি আৰু দ্বিতীয় গৰাকী মোৰ মা আকলিমা বিবি. Lordship, that Aklima Bibi was nowhere found, Lordship. Although she is stated in the 1966 voter list, she is yes, Lordship. Yes, Lordship. Otherwise, Lordship. Yes, Lordship.
Page 9, my lord. For the state, none was appear on the day of passing the opinion, my lord.
Lordship, WS is totally fake, Lordship.
Whatever was not said,
Yes,
you have
sir.
extracted it from it
Yes, yes, Lordship.
to his favor.
First committed case was made out into a good case. I have
You must go through the records.
So we start here, look at the records.
Lordship.
Texas is not carried it. For you, it is required. Not the records and then assessments. Otherwise, the system will not be to actually matter.
Lordship.
So it will take it away to.
Lordship.
Find the entry, that was primary. The efficiency of each and every document was filled up.
Lordship.
Divide this table. Some words. From different words. Sorry.
You check up your criminal matter, no, the criminal matter.
Oblige me.
You got the report?
Good.
Okay. 4 years. So you shall pay. You can hold the consistent. The second one is. Okay. City standing. This is a political city in the book of that supposed to go. The city became general. You don't tell this. And still this. This is dementia.
Still. What is the report says that he's suffering from some.
Yes, what is your instructions?
The SP was now, he is retired lordship. This was the earlier, a new one. He has give the report lordship.
No, but what does it mean? What do you understand of it and what is your instructions on the matter?
I have not received any instruction otherwise, lordship.
No, what do you submit on the basis of this report?
I apologize, lordship. I was in court number 12, so I don't find time to go through the report, lordship.
You see, it would commit at 2 o'clock. You see this report because you have to give us inputs.
Lordship.
My lord, I have another part-heard matter at 2 o'clock.
No, it will depend on him more than you.
I'll try to come.
Ah.
about.
You take your time, we'll give you time, but let him go through it.
I mean, we have not got a copy of the report. If you may.
No,
have
it's
a look.
okay. Let him see, we will give it to you if required.
Item 7.
May I please, your lordship? My lord. Page 34 is the impugn order, my lord, and it's just 7. My lord, page 31, annexure 6, my lord,
31.
31, my lord. Shifting is there, my lord, that was explained, my lord. There are 4 more. WS.
31. What's the name of your father?
Father is my lord Hussain Ali, my lord.
Hussein Ali.
Hussain Ali.
81. You have disclosed your grandfather's name?
Grandfather is my lord Tahir Ali, my lord.
Tahir Ali.
Tahir Ali.
Seventy-one, whose name appears?
71, my lord, the name of his paternal uncle, my lord, one, and other family members, my lord, Hussein Ali is the elder brother of his father, my lord, Hussein Ali.
Hussein or Hassan?
71 is my lord, father's, my lord, father's total list.
Huh?
Sorry, my lord.
Huh?
Hussein is the father, my lord.
Hussein is the father.
Yes. And Hassan is the elder paternal uncle, my lord.
But he could not identify the uncle or aunt.
Lord, in the cross-examination, my lord, he could name his, my lord, one of his, my lord, paternal uncle and the elder paternal uncle, my lord, Hussein Ali, my lord. That Hassan Ali.
When were you born?
No, that has not been, my lord, mentioned, stated in, my lord, WS, my lord. That should have been, my lord, stated. My lord. So far as the voter list of 1993, my lord, the another, my lord, part that has been wrongly, my lord, shown. The name of, my lord, the father of the petitioner has been shown as 58 years, my lord, along with the name of the petitioner, my lord.
Then what happened to his uncle in 71? Your uncle?
Yes, my lord, that should have been reflected in the voter list of 71.
So
Probably, my lord, this is the incomplete voter list, my lord.
serial number 801
Yes, my lord.
perhaps is Hassan Ali.
My lord, this is Hussein Ali, my lord.
Because if you look at serial number 803 and 804,
Yes, my lord.
it says they are related to Hassan Ali.
Yes, that is there, my lord. The Rubjan and Malika Banu.
Ah,
Yes, but this particular name, my lord, Hussein Ali, he had, my lord, categorically stated in his WS and in his deposition also that Hussein is his father and Hassan is his paternal uncle. The name of Hassan is
but
also
Hassan
there.
disappeared.
Hassan, my lord, suddenly, my lord, Hassan Hassan's name was not reflected in the voter list of 71. Probably, my lord, this is not the complete voter list. In the voter list of 65, my lord, the name of Hassan is reflected. Hassan Ali.
Therefore, we are asking him.
Yes, my lord. And during his cross-examination, my lord, the petitioner had stated that Hassan is the paternal uncle, my lord. Hussein is his father.
We are sending you the trial court record.
Yes.
It is orange flag. Please read it. I am unable to read this. And there's also the order sheet of 9/3/2015. That English also I couldn't read.
Lordship,
I couldn't read the SMS also. I couldn't read the English also.
I am trying, Lordship. 1997 চনত কপিলী ব্লকত এক্সটেনশন অফিসার
Difficult.
yes Lordship.
Mr. Talukdar, please help him. If you can, two of you can read together.
93 order to send. Yeah. Due. Okay.
Officer.
One.
It
was.
Even if you don't read loudly, please try to understand and tell us what
Yes,
should be
Lord.
there,
Yes.
contents. Omit one or two words and then please proceed.
No.
See,
No.
but no file.
No.
File petition. The opposite parties. Then examine. Submit. It's for
Office.
evidence. Evidence. I think
She's only proving the LVO report,
Lordship.
right?
Yes.
Only the LVO report. What is the cross-examination to the court, answer to the court? Next page.
No, it. Nasilu. Okay. Sorry, Paraniki.
It's very difficult also. And it is only one line.
April.
Not affected.
Not
true. Indian Asylum. Cross party is a suggestion, Lordship.
No, but what?
Evidence.
You know, a moment back, we both were sorry that we could not read it. And now we feel happy that three of you cannot read it. Earlier it was two. Now it is you.
Continue. হয়ে যে পথিক সাক্ষ্যদান নেকি সাক্ষ্যদান দিয়া ছিল
Lordship, that cross party is a suggestion. Is denied that he has not deposed falsely. He or she has not deposed falsely.
We could understand that.
What has she deposed?
Lordship, that is very difficult.
It is not mentioned. It is exhibit one. LVO report is exhibit one.
Yes.
In the first page, you'll find the second page, LVO report is exhibit one. Okay.
Yes, Lordship.
Now, what is the order of 9-3? Order sheet 9-3, that also we could not read. That is in English.
One educe. One educe for OP.
For OP file
Fixed,
after but not
but not
Hazira, but not found proof.
Found present.
Found present.
Not found present.
That means
Verification officer present.
C is present.
C is examined. Fixed and so.
Fixed 15%.
For
PS
For
WS
OPs.
proceeding side.
Further
evidence.
evidence.
Evidence of the OPs. For evidence of the OPs. That is, we can understand. Okay. So what is that order?
Opposite file.
Hazira.
Okay.
But not found present.
But not found present. Okay.
LVO.
LVOs.
LVO is present. She is the LVO. Moni Devi, she is the LVO.
She is examined, fixing 15.
So for
DWs.
PW.
A to DW.
Evidence, not for hide evidence. Side evidence.
Side
evidence. 15 তারিখে ফাইল ফিক্স করেছি। Proceedings and no OPs.
OP side evidence. Fixed when for
Okay,
OP
okay.
side
Okay.
evidence.
Just let you for understood. I understand.
Okay, post Nation convocation of complete lookup.
Evidence of examination.
Verification of the
Examination. LST কি হবে? Hostel না হলে এটা কি হবে? Reasoning না হবে? LST নাম কি আছে? LST হয় voter
You see this,
verification.
in the second flag is the Hajra,
Yes, madam.
where the proceeding as well as the lawyer are present. But they, if you don't cross-examine, your defense
have
that
got a copy, my lord,
that the LU report was incorrect goes. LU
If your
report
lordship, my lord, can you turn to the reference, my lord? The language
that goes because reference, you see, you can't challenge it now. The witness came.
that I understand, my lord. Kindly have a look at the language of that reference, my lord.
No, you see that language, whatever was there, you should have pointed out in the
Yes, my lord, that's true, my lord.
before the tribunal.
Not like before the.
So against the contrary to the evidence in the writ petition, we can't go through that.
Yes, my lord, that I understand. But when we, my lord, raised this issue before the concerned tribunal, my lord, in some of the other cases, my lord, I raised, my lord, I went there personally. They expressed their inability. They said that we are not the competent authority to set aside those, my lord, the police report as well as the other reference. my lord.
No, but that was never challenged.
Yes,
You see,
in
the
this
LP
case, my
was
lord, that
never
was not
challenged.
challenged.
You could have
Yes.
done it.
Yes,
You should have
But-
filed proper petitions.
yes, my lord, they could have filed a proper
Objection.
petition.
You see, what happens when, let us say that a confession is extracted illegally, then what happens? The law is laid down. What can be done in cases where the extraction of a confessional statement is so-called coercive?
Yes,
You know what is to be done. The witness came. That's why we were interested to read that.
yes,
Because if there's no process, that's why we took the trouble to find out the Hajra also
yes, my lord.
in the
Because
trial
it
court
was
record.
presented on that day. The
So
lawyer
it's
was also
there.
present. And the, if your lordship, my lord, kindly.
Just a moment. Just a moment.
Reference. Reference to the.
পুলিশে এনকোয়ারি করা হয় না হয়তো একটু এনকোয়ারি ডান বাই এলপিও
Yes, inquiry considering to explain to reference protection. But the legal agency from.
আমরা রেফারিং করেছি রেফারিং করছে বলে কি করবে এলপিও এলগো রিপোর্টের উপর বেস করে ইয়ারও তো খেয়াল লাগে
Can you present in the reference? People working with us.
What he has stated, Lordship, something I have understood, Lordship. He visited the house of the petitioner, and during inquiry, he could not produce any document during his inquiry, and that Lordship report was submitted before the ERO, Lordship.
okay.
Yes, that was.
Okay, we'll take a break and come back.
My lord. Reference report, my lord, which was submitted by the concerned SP, my lord. On the basis of LGR's report and ER's report, my lord, the reference is submitted. My lord, will kindly come to page 26, my lord, of the petition, my lord. Annexure 5, page 26. is
No,
the
no, you
model.
see, this goes,
Yes,
whatever defect was there
my lord.
in this, you can't take advantage of it because the witness came and deposed.
That I understand, my lord.
Once that is there, we can't go into the document again and then verify because in the cross examination, you could not
Yes, my lord.
demolish that. And you are
lord.
not present.
Yes, my lord, but I just wanted to show that, my lord, how the language has been used, my lord. The gender has been changed, my lord.
No,
The
that's okay. You see, here it is written male.
Yes,
But somewhere there may be a mistake. That mistake doesn't make a document, what do you call, unacceptable.
my lord.
You just want to say somewhere it is written in F.
Yes.
Correct?
She, my lord, 2 times, my lord.
That's okay. You see, it's not your case that somebody else was examined by the LVO and the data there's a mismatch. Here, in this case, the LVO did an excellent work. He even gives the height of the person as 5 feet 5 inch. Therefore, he must have taken trouble to measure the man. You are not saying that, no, he's not a mismatch. He's not 5.5. He was 6 feet. You are not saying that. The complexion is given as Swarthi. You don't come and say that, no, it's wrongly written. So this man has done the duty, but perhaps he or she, he made a mistake. occupation is cultivation. You don't say that you don't do cultivation, you are a headmaster of a school. You don't say that.
No, my lord.
So those things are not material for us. And in the evidence, you don't come and say that the evidence was available and was not given. Then you will also come to that the documents. Come to the document.
My lord.
This Annexure 1
Yes, my lord.
is the Gambura certificate.
Yes, my lord.
This was issued when
This was issued, my lord.
date is unfortunately not there.
Date is not there, my lord.
Correct. And it is not your case that this was given in 97 when the LU did the inquiry.
My
So this is a document which was not there. Now come to the document number 2.
My lord.
Now this is
Legacy
this is the NRC detail.
NRC detail, legacy data.
You have not been able to show that this NRC detail was available then in 97 to you, because then it was not in the public domain.
Yes, my lord.
So you could not have obtained this in 1997 and
Yes.
produced. So the document number 2 also goes. Come to document number 3, certified copy of 2014. It is not your case that 2014 document you produced in 1997. Correct.
My lord.
So before you even start your submission, we have gone through it.
To show, my lord, they have the reports are prepared, my lord.
Doesn't matter.
My lord.
These documents are not there. You can't show even to us now that they were documents and were disbelieved by the
My- my-
LUO. So don't worry. These things we have already seen before. Before you started your submissions. Don't worry about that. Other things on merit. Because if you can show a document where you could connect yourself to your projected father.
The voter list of 1993, my lord. And regarding that shifting part, my lord, I had explained in my WS, my lord, that was not disputed by the state. Nor, my lord, anything has been made, adverse remark has been made by the constitution.
Where? Which page?
My lord, the voter list of 93, my lord, page, my lord. At page 21, my lord. Vernacular.
21.
My lord.
Tarajan Gormara.
Yes, my lord, that is after shifting, my lord.
Where you have explained in our written statement.
Page 31, my lord. Para number 4, my lord.
Where is that statement? Had been living in village Salmara Borgao.
Salmara Borga.
Parents
PS
with the staying
district,
residence Morigao.
during the year 1965 to 72-73, and thereafter the appearance of the OP along with him was staying in the aforesaid address, meaning thereby that the address that has been mentioned in the top, my lord. Gormari Tarajan.
Okay.
My-
And where is the finding of the tribunal on this point?
Yes, my lord. Kindly, first you will kindly come to, my lord, page 36, my lord. The last paragraph. It starts from the last paragraph, 36.
Yes.
The first doubt which arose in the instance case is the voter list of 65 and 1971, as because though the house number 52 is in both the voter list, the center number and part number is not indicated in the voter list of 65. And as this has not been proved beyond any reasonable doubt as required in the law. Secondly, the OP in his cross-examination could not name the younger paternal uncle as Rahmat, nor the younger sister, within bracket, aunt of his father as Fulbanu, which are of course indicated in Exhibit 4, that is Jamabandi copy. Thirdly, in the voter list of 1993, exhibited as Exhibit 3, the age of Opie's father Hussain Ali is shown as 58, where in 1971 his age was shown as 24. If we calculate the real age, the Opie's father taking 24 years in 1971, her age would have been 46 years, and as such, there is a difference of 12 years, which is another factor not to rely on these documents being procured stroke projected documents. Moreover, there is no any relevant voter list of Opie's father on his paternal uncle of Opie stated that they died some 8/9 years age in his cross-examination. These are the reasons. Please.
No, so because of the change of village.
The
Question
voter
is
list of
it is
Millot
not there.
65 and 71, Millot, in one of the voter list, the center number and part number was not Millot stated.
That's one part. But because of that shifting, there no adverse comments were made by the tribunal.
Yes, Millot, no adverse comment.
But Mr. Sharma,
Lordship.
still we think that this is a case where it has to be remanded. Number one, the cross-examination was not taken into account. The second is that the entry made in the document annexure, this exhibit 4, which is the Jamabandi.
Yes, Lordship.
The Jamabandi is a entry which is made in 1977,
Yes, Lordship.
and 1977 was before reference,
Yes, Lordship.
where after deleting the name of the grandfather, their names were brought in. There must be a discussion on the document exhibited.
Yes, Lordship.
So these are the two grounds we think it's a case of remand.
Lordship. Otherwise, Lordship, regarding Jamabandi, Lordship, there was no pleading, Lordship, at all, Lordship. Regarding Jamabandi, Lordship,
No, you see,
and
question of pleading will not come here.
Lordship.
In the evidence, it is there. You
is
don't
exactly-
reject that on the ground that it is beyond pleading. you could have understood that the question is asked that that this evidence is beyond pleading. That is not not the stand.
Under his lordship. It is a post 71 document, lordship. One thing, lordship, and apart
No,
from
no,
that,
you see, one thing is, it's a the entry is post 71. But you have not demonstrated that the document itself is not prior to 71. You see, this is the state which is functioning.
Yes.
Earlier, when we had handwritten, I've said it so many times.
yes,
Earlier, when we had the handwritten Jamabandi, the year of the Jamabandi was always written. The period of settlement was also always mentioned. Then that is how we saw the document. Now you have electronic and you have omitted this year. So where there is a presumption that this document, the first entry of the name of the grandfather was not prior to 1971. You don't give the period of settlement. You see, somebody must arrive at a definite finding.
Hmm.
The tribunal must say that, well, this document is prior to 1971. That is not the finding. How can we interpret in a rate proceeding that a document is post 1971?
so lordship. So documents should be proved, lordship. My humble submission is that.
No,
lordship.
sir, you see, must be proved. Is it your case that the document is not proved? Exhibit 4, it is marked as Exhibit 4.
Yes, lordship.
It is referred to in the opinion also. It is referred also in the opinion,
Lordship.
that there is no discussion.
Yes.
Because Mr.
And-
Sharma,
Yes, Lord.
from your argument and the previous arguments which was advanced by Mr. Payang, he always shows proved. The document is required to be proved. But this is again something which has a civil consequence.
Yes.
So it must be on the principle of preponderance of evidence. You see, we have tried to examine, both of us, we have tried to examine many judgments
Hmm.
of on the foreigners tribunal, foreigners cases. Your foreigners order,
Yes, Lordship.
we find it very strange that the principles of the nature of pleadings or the documents which is required is not spelled out anywhere.
Yes, Lord.
Now, under that circumstances, you see now, look at this case. Here, what is required to be proved? That the proceedee is a person whose father or grandfather were there in 1971.
Yes, Lord.
Correct? That is the only thing. Now, how does the tribunal arrive at a finding that we disbelieve you because you could not say the name of your uncle? Think of people like me. Every day I have to ask names of you and then write in the order. Every day.
Yeah.
210 working days in a year. Every day I ask your name and then write.
Yes, Lordship. That cannot be, but Lordship, Lordship, after 1971 to 1993, Lordship, what happened to his father, Lordship? That was nothing has been
But you see,
mentioned, Lordship.
that's not the requirement. If one document I can
And
show,
1993, utterly suddenly appearing, Lordship, his father's name appearing, Lordship,
no, what is
at
what-
different village, Lordship.
you see, this is something which I'm asking you every day.
Yes, Lordship.
What prevented your APP to ask that question?
Yes, Lordship.
You see, in a cross-examination, does silence mean something or it does not mean something? Can silence in a cross-examination be interpreted in some way?
Lordship.
The state does not ask something in cross-examination. Can that be a ground to disbelieve a document? Who is the uncle? Name him. Otherwise, I don't believe that you are the son of so-and-so. Can that be a ground? Let me take a situation. You see, I have a quarrel with my uncle. And in that quarrel, I told him that I'll never look at you. Correct. So I defer anybody asks, I said that my father has a brother, but I don't want to say his name. And when I go to the court also, I take the same thing that my father has a brother, but I won't say his name. I dislike him, I don't say his name. But would it be a evidence to say that I am not the son of my father? By any stretch of imagination. I don't know the name of my aunt. I was just now discussing with my brother. I have a friend from my school time. We called him by a nickname. And now I forgot his full correct name. We met him about 15-20 days back. And he told the correct name. And I told him, no, forget it. We know you by your old name. And so we refused to acknowledge his actual name because we have habituated to call him by his nickname.
Lordship. কৰিছে Exhibit 4. Exhibit 4.
It's an entry of 1977.
Yes, Lordship.
The original first name, when it did enter, is not there.
Yes, Lordship.
But then how is somebody else responsible for that? If the state does not give a certified copy indicating the name, the year of the Jamabandi,
No.
then it was for the tribunal, if it is to be disbelieved, to call for the original record and see it.
Yes.
One thing by the may submit continue. What if the nature of evidence adduced by the petitioner before the tribunal with regard to the matter the Jamabandi may kindly be seen, my lord. The nature of evidence, my lord, what evidence he has given. The lordship will find the only statement is
Mr.
that.
Pang,
Yes.
please remember, this man, the proceedee, he is not before the court to prove the ownership of the land. He is required to prove his
This
ancestry.
linkage. Yes,
Correct.
yes,
For that, he presents Exhibit 4,
yes.
which contains the name of the grandfather and in the end of, instead of the grandfather, their names come in.
Yes.
So he is linking himself.
That's why, my lord, if there is no explanation, the tribunal cannot presume, my lord. Your lordship may kindly see what is there in the evidence. Evidence he has said, my lord, with regard to the land documents. Oporipokkho, your lordship may kindly say page 32 is the evidence.
WS.
No, page 32 is the evidence.
Yes.
Not evidence. It's WS.
What he has said in it, if it is WS method, what is there in the evidence as WS? Evidence. Page para 4, my lord.
পিতৃ ককা দেউতাৰ নামত হালমাৰা বাৰী কিছামতত ম্যাদী পাট্টাৰ মাটি আছে।
Say, This is the only line.
Yes.
At least he should say, we have learned from when, how it is secured. This has to be there because my lord,
How it is acquired?
no, my lord, when they are occupying this land or when this, my lord, these are vague statements. Mayor saying that we have a land in that place.
Mr. Pine, very difficult for us to accept that. You see, let us say that the proceedee is a very young boy of voting age is 21. He's a young boy of 21. He says that his father and grandfather's name is there in the land. That means 20 plus 20 is 60. This is a Jamamandi of 1977. 77, even if you minus 20 and add 40, that means age of the father and the grandfather at that point of time would make it prior to independence.
Exhibit. Well, that is very important because this is very only অপরিপক্ষৰ পিতৃ ককা দেউতাৰ নামত হালমৰা বাৰিসীমাত ম্যাদী পট্টাৰ মাটি আছে this much only
Oh, you have not read the cross-examination.
Examination.
There's nothing. You don't disbelieve it. Even the cross-examination, there's no cross-examination to that point.
My lord, we have to remember, my lord, in original cases, is this burden is there on their part to prove everything. What is there, my lord? There is
That's right. We are
no
asking
reverse
you,
burden on the
what
part of
was
the
he
state.
required to prove? Was he required to prove the land? No.
My lord, if documents, they are bringing the documents, they have to explain it properly on what basis they are claiming. If this document is of 1977, in fact, my lord, my submission is if this document is of 1977, it has no, my lord, relevancy at all.
Then you are wrong. You have not read the document again. Read the document. It's a mutation order of 1977.
Yes.
Does not make it a document of 1977.
Yes. Put in the document by
So-and-so-
parcels lordship.
So and so 77 hukum mate.
Yes.
But the entry of the grandfather is there.
It's serial number 1.
You're not trying to demolish the entry of the grandfather in 77.
My lord, DW1, what he has said, made it one against. My lord, this is
You've
evidence.
seen that, huh? You read it.
Evidence on the DW1.
Yes.
My lord,
You'll also remember, if you come to the opinion, every submission you are making would have been acceptable if the tribunal had rendered a finding on Exhibit 4. There's no discussion at all.
my lord, what my submission will be, my lord. But I have gone through the document, my lord, the exhibit 4, my lord. There it can be seen one Mohsen Ali is there, my lord, and one my lord, this Tahir Ali
No,
is
no,
there.
we are not on that. See, the normal rule is whatever is produced there before the tribunal.
That has to be discussed. That
Beyond that, we can't go.
yes.
The same rule is applicable to you unless it is explained in the order. You can't fill it up by your arguments.
That is true, my lord.
There has to be some discussion, accepting, rejecting.
If we, my lord, if we go to the document, my lord, I understood that, my lord. If we go to the document, why it is not discussed probably? My lord, if,
Probably we don't.
my lord, may kindly see, though Exhibit 4, even though we accept that Exhibit 4 is there, Exhibit 4 doesn't contain the name of the petitioner, my lord. It only shows one Tahir Ali was there. And
You see, you are fundamentally incorrect. I'll tell you that when it comes to Exhibit 4. Are you aware of the period of settlement for which pattas are issued? It can either be a 15-year or a 30-year lease.
yes,
Correct? Any question on that? We can show you the provision
I'm not
of
saying
the Assam Land and Revenue Regulation, which says that the patta would be periodic.
yes,
Periodic patta would be of 15 years or 30
30
years.
years.
Now, if the name of the grandfather is there, 77, the name is struck off. Correct. So the patta would be for 30 years. Now, that's why we are saying, when I told about the age of the person, grandfather's name is there. So that would make, and in
Grandfather is
the
available
meantime,
there.
no, in the meantime, the father is there.
Yes, father is there.
And in after that, the son is there.
Son is not there.
No. We just,
Yes,
the son
yes.
is there, the name is entered.
No.
Oh, father is there. So
Father
20
is-
years. Let us say 20 years gap.
Yes,
So when the name of the father comes in, he must be of a major. We take it that he has got his name entered when he was 18. Then also this document is pre-71.
yes. No, my lord, I'm not on that, my lord.
Hmm.
My submission is not that. I'm not doubting that Tahir Ali was not there. Tahir Ali was there. And one day,
No, we are going to the date of that
yes.
entry.
Maybe prior to
Where-
77, prior to 71, we don't know because entry is not there. Your lord, we can presume that probably no issue on that. But my lord, this document will not demonstrate the relationship between the petitioner and the father or to the grandfather. That is the point, my lord. Because here we accept that one Mohsen Ali, whom he is claiming to be the father, was there. And grandfather is there. But to link himself with Mohsen and this Tahir Ali, this document will not, my lord, this document will not help the petitioner. Because
It is
his,
not Mohsen, my lord, it is Hussein is there.
Hussein, whatever may be, the father and grandfather, to link himself with father and grandfather, this document will not help at all. That is the only. It should have been discussed, but even though, my lord, this document has no relevance because, in fact, he has not explained why it is, my lord, how it would help him. In absence of that explanation, the tribunal is unable to, my lord, explain. Because he has to explain
No,
why this
tribunal
document
doesn't
has
say
been
that. Had the tribunal said that, we would have been glad to accept it. If the tribunal renders a finding to that effect, we would be gladly accepting it. Read the opinion.
Yes.
First is rejected because in the voter list, the center number is not there.
Yes.
Now, for deficiencies in your certified copy,
My lord, we accept, my lord, this is certified copy issued by the mother.
so
But
if the
it is
center is
their
not there.
documents, my lord, when they produce before the tribunal as their evidence, they has to explain this, that this is not there, this is not given. We cannot presume, my lord.
No.
If
When
they,
it is a certified copy, it is presumed to be correct.
we
So
accept
if
that.
there is a deficiency, you see, the tribunal is not powerless to call for the records.
My lord, we are not saying it is not correct, my lord. We are saying, my lord, whatever, if they have seen, suppose a documents where there his name has been wrongly spelled. When he is producing the document, he has to explain this in this document, this is wrongly spread.
How will you know 66? What is the center number?
Yes.
Can you tell us?
It is their documents, my lord.
No, no, no.
Ultimately, they
No,
have
you
claimed
see,
for that.
You are the state. You must have a mechanism to tell us that if there is a deficiency in the certified copy without the center number, today can you get access to that center number, which is not there in the
My lord,
certified copy?
Definitely, my lord, we are not saying
So
that.
we on this ground itself will direct that once the entry is not correct and the court is doubting it, let the tribunal call for the original record and verify. Because you see, you can't, you are discarding a document, no cross-examination on the point of that exhibit 1. You are discarding it after he loses his opportunity of defense. Can that be permissible? You see, what happened today, we are, you see, you transpose yourself from year to year. You are arguing a writ appeal or a writ petition before us. Now that affidavit is left blank, would you like that I would dismiss your writ petition on the ground that the affidavit is not correctly verified without giving you an opportunity of rectifying it? If you are here, you will be happy. But if you are there,
Yes.
and if I dismiss your writ petition only on that ground, that it is not in correct format, dismissed. The name and other particulars are not correctly filled up, dismissed. Not correctly verified, dismissed.
No, that is true, my lord.
Yeah.
But
Then because you see a misdescription of a property, Supreme Court says that even in execution stage, you can take that plea of misdescription of property.
yes, my lord.
Because we are groomed up to refer to Order 723 about misdescription. And even if there is a misdescription, say you have purchased a land. Let us say that your father purchased the land.
Yes.
Now, when you are going to the GMDA for a building permission, they tell you that your north and south boundary is not matching, and they are refusing permission to you. You can still go to court and get your deed rectified under 26 of the Specific Relief Act. The vendor can still come and say that, well, okay, I wrote wrong. Left would be road, right would be land of Mr. Sharma. It can still be rectified. So when the state, when it comes to property and asset, permits you to use the provisions of law to come over.
So that is definitely, my lord. We have no, but my lord, my point is, my lord, when because it is a citizenship, my lord, they know we don't know what is their contention, my lord. It is their personal knowledge. They have to know everything, my lord. We cannot have personal knowledge of their life. So whatever is there, if they are residing in a particular village and they shifted from that
No,
village.
you're still not looking at this. I told you page 36. Come to the last paragraph, page 36 opinion. We started with that. First doubt which arose in the instant case is voters list of 1965 and 71, as because though the house number 52 in both the voter list, the center number and part number is not indicated in the voter list of 1965. And this has not been proved beyond reasonable doubt. Now, is the evidence in a tribunal beyond reasonable doubt? That is the first question we asked you.
This may be ignored, my lord. 71, 65. In fact, my lord, we always ignore, my lord. 65, 71. One person's name is there. We in fact ignore all these things. We only want a link to this person. Even if, my lord, the 71 and 65 voter list, the father or grandfather is there. If he can link somehow by any documents, that's enough. We want only that much. We are not going beyond this on these technicalities, my lord. If he can prove somehow by linking himself to these documents, then also, yes, we can accept it. I have, my lord, accepted it. I have no.
But just tell me, come to the second part, which we have not read. Secondly, the OP in his cross-examination could not name the younger paternal uncle as Rahmat, nor the younger sister aunt as father of his father as Fulbanu. Now you see, who is rendering a finding of fact? Tribunal. Tribunal says that your uncle is uncle of X is Y, and aunt the sister of father is Z. It's a finding of fact.
Yes.
And why this is refused? Because he could not say it.
Finding of fact on exhibit 4.
Exhibit 4 is the.
Correct.
Jawab.
So you see, the tribunal does not say that we disbelieve that this Rahmat is his paternal uncle, and we disbelieve that Fulbanu is his father's sister, because the proceeding could not say that. Then we understand. It's just a way of writing. But he says that no, his father's brother is so and so, and sister is so and so, and he could not say it, and therefore evidence is discarded. But now, whatever
Evidence
you are
of the-
submitting, that the document is it has to be proved beyond reasonable doubt. Let us accept it for the time being. Then also, what is the finding on exhibit 4? No discussion.
Yes. No, my lord, my submission is the exhibit 4, even though we accepted exhibit 4 is a valid document. My lord.
Can we
need-
record that in the order?
Yes, my lord, we need, we
Okay.
have, my lord, if we accept that exhibit 4 is a valid document, my lord, that can the petitioner prove that this, my lord, only what I want, my lord, if the petitioner could prove himself to the son or grandson of these persons, there is no case at all. That much only, my lord, by some document. Where is that?
Voter list of 1993. And
That is the only missing point, my lord.
the only linkage that has not been disputed by either by the tribunal or by the assistant.
No, you
Government
take a
petition.
decision, because I will be glad to give a finding, but that will have a ripple effect on you. You'll open Pandora's box if you permit us to write and determine the evidence.
No, no, my lord, for argument's sake, if we
So
accept.
it's not a question of argument. You see,
Yes.
we are doing some constructive work here.
Yes,
It's
If-
not just not the academic part.
if we,
The second part is we have to dispose of a matter.
yes, my lord, if we remand
Now,
this
if-
matter, my lord, if we remand this matter on the basis to discuss this particular document, my lord, we have no issue, but whether it will help the petitioner at all, because we
No,
accept.
that may
if-
not. But does it justify a court not to record the evidence?
That is true,
Not
my
to
lord.
discuss an
Evidence has-
evidence?
That, my
You
lord,
see, I have 5, you see, what do we do? You cite 20 judgments on a point. We find it is hopelessly unrequired. What do we say in the order? That Mr. Payang has cited 20 judgments or are irrelevant and they were discarded. But we have to take a pain of writing this 20, referring to these 20 judgments.
then your lordship may remand all this matter for
It has to
discussion
go.
on the.
Once there is no
all the
discussion,
doc-
it has to go.
Yes, to discuss the available materials on record, then first press order.
Huh? We'll pass orders in chambers.
Yes, yes, yes.
Well, deeply
Just
black,
cite the names.
deeply black.
Just a moment. It. Print out. Yes, you got the report. Your original report has come.
Lordship.
Yes, you've gone through the record.
Lordship.
Yes.
The Lordship, the report is there. As per the report, Lordship, three conditions are there, Lordship. In NCT, CT brain, size tip of ischemic etiology, Lordship. And second one is, Lordship, systematic hypertension is there. And third is, Lordship, left hemiparesis due to ischemic stroke, Lordship.
Yes.
And one earlier, Lordship, cerebrovascular accident has also took place, Lordship, in August 2023. If Lordship, if I look into the report, there is no seriousness is not written there, Lordship.
Now, the first part of the report says, what are my disabilities? First part of the report says I have become forgetful. My day-to-day. Kind of. Problem is he has been diagnosed with Alzheimer also. The report is before this court.
Yes.
But still, there's a report of that he is suffering from Alzheimer. The discharge certificate of 3rd July 24 from GMCH.
When we see the last report as well as the present report, now also his on his appearance before the doctor, they have found that he has UML facial palsy. Perhaps it means the left side of the face is deformed. Then left homonymous hemiano, hemianopia. This I've just checked. It means the vision, the left eye is lost. Then down below in the last page, hand grip, left side is 95%. And in the right side, spasticity has set in. Spasticity means that the deformity in the entire left side is there. Power in the upper limb is 4 out of 5. That means there is a degeneration. I think we are inclined to grant bail to the petitioner. Correct? But we'll have to make the order conditional.
My lord.
Every 15 days, you'll have to go and report to the no, to the
Jail.
to the jail, because now police doesn't have control. How far is the jail from your residence?
8-9 kilometers.
8-9 kilometers.
If it's not a proper, 15 days is okay.
15 days. Make it 15 days. 302. That's will be offense. 15 days you report to the jailer.
Every 15 days.
Every 15 days.
If a direction can be taken, that they will give us a acknowledgement of reporting. Otherwise, sometimes it happens that they will not acknowledge and another issue will crop up.
We'll maintain the record.
We'll maintain a
I
record.
will maintain. Just if they just acknowledge my presence, that's all.
Okay.
Yeah, my lord. Excuse me, my lord, my another matter is being called. If I may, my friend is here. I'm deeply obliged.
Mr. Baru, you want to add something?
No,
To what Mr. Das has said?
No, my lord.
Okay. But Mr. D.K. Bhattacharya, and counsel for the applicant, as well as Mr. K.K. Das, learned APP for the opposite party number one's state. Next paragraph. This, by filing this interlocutory application under section 389 within bracket 2 of CRPC, the applicant has prayed for the applicant who is the convict. In Sessions case number 224 of 2015, has prayed for suspension. So 15 decided by the Sessions Judge Morigaon by judgment dated 2/6/2022, has prayed for suspension of sentence. Full stop. The learned counsel for the applicant has submitted that the applicant was taken for medical evaluation before the Guwahati Medical College and Hospital at Guwahati, and referring to the medical report annexed to this application as Annexure 3, it is submitted that the condition of the applicant is deteriorating. Full stop. It is submitted that the two sons of the petition, of the applicant, namely Shanti Bordoloi and Ranjan Bordoloi, are also lodged along with the applicant in the district jail, Morigaon. And as per instructions, as per his instructions, they are taking care of the applicant, who is about 72 years of age. 72 or 75?
75.
75 years of 75 years of age. Somewhere I got 72
In the report, Lordship.
in the report. 75 years within bracket. In the medical report mentioned as 72 years. Next paragraph. The learned APP has opposed the prayer for suspension of sentence, and it is submitted that the applicant has been awarded life imprisonment by the judgment and order, which is impugned in the connected appeal. And it is judgment dated 2/6/2022, impugned in the present
Sentenced 8/6.
and sentence on 8/6/2022. So accordingly, it is submitted that there is every chance that the applicant may vanish to escape serving out the sentence. Next paragraph. It is seen that from the, it is seen from the medical document annexed to the applicant application as Annexure 3 that the applicant was admitted in Guwahati Medical College and Hospital on 1/7/2024 and was discharged on 3/7/2024. And at that point, the applicant was diagnosed of a case of is diagnosed of suffering from Alzheimer, ALZHEIMER disease and systemic hypertension, SYSTEMIC, hypertension. It is recorded in the order dated 19/8/2024 that the applicant was referred to GMCH for a re-checkup on 17/7/2024 and again on 24/7/2024 and in the last re-checkup, it was done at Neurology OPDF, GMCH. Let's stop. Next one, the learned APP has produced a copy of report from the Superintendent of District Jail, Morigaon, and the original of the said report is also brought to the brought on record by the registrar by the registry, which is a letter dated forwarding letter dated 9/9/2024 from the Superintendent District Jail Morigaon, by which the medical report of the applicant, namely Brojeshwar, BRAJESWAR, Bogley, is forwarded. As per the said, as per the report by the professor, Department of Neurology, GMCH, Guwahati, the applicant is found to be suffering, had attended neurology OPD on 17/7/2024, 8/8/2024, and 5/9/2024, and amongst others, he is found to be suffering from left UMN facial FACIAL palsy PALSY plus sign, left HOMO NYMOUS, homonymous HEMIANOPIA plus with left side spasticity, SPASTICITY plus within bracket tone TONE, with power of left upper limb as 4+/5 and lower limb at 4+/5, and hand grip at 95%. Stop. As per the NCCT of brain, it was a spelling. So, .D. Diagnosis, left hemiplaces, past so-and-so, systemic hypergenia. All these are tick mark. You do one thing, you extract the report instead of the statement. The patient attended neurology OPD. From there, you just put this report completely till the end. Two last pages. Next para. Accordingly, on in view of the report of the GMCH suggesting that the applicant is suffering from left facial palsy and left homonymous hemianopia which is suggestive of loss of vision in the left eye. Comma, the court is of the considered opinion that the medical condition of the applicant would entitle him for bail. Full stop. Next para. Accordingly, the court is inclined to provide that if the that on the applicant providing a bail of a sum of rupees 50,000 with one surety of like amount to the satisfaction of the learned sessions judge. It will be session judge. Session judge, Morigaon. Morigaon. The applicant, namely so and so, shall be released on bail on the following conditions. Number one, that the applicant shall physically be produced before the superintendent of the district jail, Morigaon, every 15 days. No, one more. Okay. Once every month. Shall be produced once a month before the superintendent of district jail, Morigaon, preferably within 12 to 15th day of each month, starting from present month of September 2024. Then, as a condition of bail, it is directed that the applicant shall make no effort to meet the victim or any of the family members next. During this period, during the period when the petitioner is on bail, he shall not leave the territorial jurisdiction of Morigaon without prior written information to the superintendent of district jail, Morigaon. The applicant should also submit an undertaking before the superintendent of district jail, Morigaon, before he is released, that he would surrender before the said authority as and when so directed by this court.
My lord, I have a request, please lower the amount of bail bond as he belongs from very poor background. Lower the amount of bail bond. 50,000 is very high for him as he belongs from very poor and marginalized.
We will see to that after some time. It is made clear that if in the event the applicant is not produced before the superintendent of district jail, Morigaon, within the time as allowed, it would be open to the superintendent of district jail, Morigaon, to take steps for taking the applicant into custody. Okay, bail amount is reduced to 25,000. This interlocutory application stand disposed of. We should impose one more condition, I think, Gagan, that the law will not take an adjournment when the matter is called up for hearing. Huh? One more condition. Bail is granted as a condition for grant of bail. It is also provided that when the matter is listed for hearing, or the counsel for the applicant shall not pray for adjournment.
Obligement.
Time being item 6.
Mr. Sharma will just indicate the context. Please come to page 11.
Lordship.
Page 11, para Roman 2, small,
Yes.
second part. The OP DW1 absolutely failed to explain his evidence also in his cross as to why his parents' name has not been included.
Yes.
So question of why was never asked, I think. Because in the cross it is not written that he is on this question he is unable to say an answer. But the fact is that in the cross examination, the name of the father and all were asked. That was not considered. That is the only reason we are trying to think if it can be remanded back.
Lordship.
Because once there is something in the cross, the tribunal will have to give a finding.
I have granted the cross, Lordship. May I read the cross part? Lordship? মোৰ নাম মোহাম্মদ সৈফুদ্দিন, বয়স 44 বছৰ, পিতা স্বৰ্গীয় ইব্ৰাহিম আলী, ঠিকনা গাঁও চাউলুক, ডাং, জংগল ব্লক, থানা যমুনামুখ, জিলা নগাঁও, অসম। মোৰ ককা দেউতাৰ নাম স্বৰ্গীয় ইয়াকুব আলী, ককা আইতাৰ নাম মই নাজানো। এওঁলোকে মোৰ জন্মৰ আগতে ঢুকায়। মোৰ ককা দেউতাৰ দিনৰ পৰা আমি চাউলুকতে আছো। মোৰ দেউতা ইব্ৰাহিম আলী, তেওঁ যোৱা 30 বছৰ আগতে।
You see,
Yes.
if your APP was knowing of the Mohammedan law at that time, he would have asked a simple question that in Sabe Barat you go to offer prayer at Kabristan. For whom do you pray? If you don't know the name of the grandmother, for whom do you go and pray? A simple question would have exposed him because he's supposed to pray for people who are in the graveyard. Then the second question would obviously be, is your grandmother buried somewhere? He doesn't know that. That means they have no record of the stay in the country.
Lordship.
Because normally in a Mohammedan way of life, they want to keep the dead bodies as close as it is possible. As I've attended many janazas in Guwahati, they make an endeavor to place if the space is available, to keep the near relatives in a very closest possible space. Mr. Sikdar, am I right? That is the usual process. Usual thought process. It may not happen, but that's the usual first approach is to keep closer.
Yes.
Correct?
Yes.
Because the name has come and the
No.
traveler says that he did not say they are not included in the voter list subsequent to the year 1971. If that question is asked and not answered, then adverse
Lordship.
presumption can be taken.
Otherwise, Lordship. Hey.
No, everything is against him.
Yes, Lordship.
Nothing is in
No.
favor of Mr. Tabadar,
Yes.
except for this cross. This cross has built up a case for Mr. Tabadar, which perhaps he also does not know. Mr. Tabadar, you did not read the LC trial court record.
Otherwise, Lordship,
But don't do
this
that.
cross also.
You are supposed to assist the court. If you don't do it, and if the court starts reading everywhere and find out the answer for you, the sorry state of affairs. You are expected to assist the court. You see, we watch everything. Mr. Sikdar was spending some time reading the record. We have seen that also.
Otherwise, Lordship,
Because if you don't read the records, you'll definitely not know. 2 days back, we expressed our anguish against a lawyer because he did not do anything. When we went with the record inside, then we found out it is a good case. We had dismissed in the open court the matter. But when we look at the record, we find that it is a good case and we had to list the matter, express our anguish in the order against the lawyer for not assisting us. Because if we take the same view, if nothing is there, we start dismissing the matters, you will be at loss. We are not bothered by it. If somebody goes to Bangladesh, we are not affected by that. Our heart is not burdened. If you don't assist, nobody reads it. We have to read everything. We have to interpret everything. We have to take care of the Evidence Act. We have to take care of the pleadings. We have to take care of everything. Then why we need you? We both feel that we can be at home and then dispose of matters. And with this, which we are finding it out, we'll do better than your assistance. And there's a second aspect, Mr. Tabadar. If you allow us to build our ego by thinking that we are better than you, then you know what is going to come. Because then we don't need the assistance, we don't take your assistance. Then what happens? We think that it is a question of citizenship, we should go look deeper into it. We are examining. Otherwise, disposal of 1 or 2 cases in a day That's not a cup of tea for both of us.
You take time, take the pain to go through the records. That's the job of a council. And a council of your standing. Go through and find out and tell us what are your points which you want to rely on. Otherwise,
You see, look at the effort we took in interacting with Mr. Pahang. He had made a lot of forceful defense to defend the order. Such a forceful submission. That means he did some homework, and then he's addressing us, Mr. Sharma. He had taken pains to tell the court what the fact is all about. And instead of you assailing the order, it's the court's job to assail the order, which we don't have any business to do. That's why we are again expressing our anguish. That calls for a dismissal, in fact. I'm telling you, we are really anguished because if you don't assist us, dismissing is something we could have disposed of 10 cases by now. Go through the records and address us. We take it up after a week. Because it has to, the defense must come from you. We don't find out, dig things up and then pass an order. You do your research, you make your submissions, we start afresh. All sides are represented. This is item number 6. All sides are represented. On the prayer of Mr. A.S. Lavadar, counsel for the petitioner, the matter stands adjourned. List after a week.
My apology, my lord, my sincere apology, my lord.
No, you see, we are not happy with the apology. We must make it a point that when you are addressing the court, you should go through the trial court record. It's as simple as that.
Obliged.
Item 9.
That's why we pointed out, Mr. Sikdar took some time. We saw him reading the records. That is well appreciated.
In fact, my lord, I requested all of my friends before addressing the court, if everybody should go through the records. But very few of us looking the records, my lord.
Expected, in fact. But thank you if you are addressing your colleagues for that. Thanks. You deserve a thanks at least.
Obliged, lord.
Yes, okay.
My lord, in this case, my lord, I have gone through the records. I have seen some, my lord, some sort of the missing in passing the impugned order.
First, take us to this land document which you
My lord,
are referring. How did it
land-
connect you?
Land documents, my lord, there is a-
Exhibit 5.
yes, my lord.
How does it that help you?
That is an annual Khiras Patta. At page 30.
Because if you are relying on this,
My lord.
this Khiraj Patta,
Yes, my lord.
this Khiraj Patta is settlement is from 2004. Doesn't help you in any way.
Only, my lord, is that my name, my brother's name are shown, and we are son of Amiruddin.
Please show your written statement. Have you mentioned your names of your brothers and sisters?
My lord, that is
21, page
as
21.
usual, my lord, the WS is not in the full-fledged manner. It is a half-hearted piecemeal WS, my lord,
Okay.
not mentioned.
In your
But,
evidence, have you
but
stated that?
my lord,
Have you introduced your siblings in your affidavit in evidence on affidavit?
my lord, evidence in affidavit, lordship, we have in evidence in affidavit,
Page
my lord,
34.
at page 34.
I think your brothers and sisters are not also stated here, so therefore this land document goes.
My lord,
If
that
that,
is-
if that goes, then there is no connect.
my lord, here, my lord, in the evidence in SIP, please also simply mention the land documents.
No, that's why we are saying, you
Yes,
see
my lord.
2004 document, if this is not proved, then your connect to your projected parent also goes.
But he has exhibited one documents, that is a judgment of the foreigners tribunal, where his brothers was declared not foreigners.
Where is that? This is something we missed.
My lord,
At least I have missed out. Where is that?
my lord, that is,
Exhibit, is it exhibit 7?
it is exhibited, my lord.
Exhibit 7? Is it?
Exhibit, my lord, it was in the WS, it is not mentioned, but it was exhibited as exhibit 7.
Is it page 44?
Yes, my lord, page 41, my lord. Page 41.
What is this page 44 then?
41 is the type copy.
Oh, acha, okay. Who is the proceeding here?
Here, proceeding is Nur Islam alias Nurul Islam Sheikh, his brother. But this has also been discussed in the impugn opinion. The learned tribunal has not accepted it, showing some discrepancy of name of father. That name of father in the
In this opinion, it is Amiruddin.
yes, my lord. Amiruddin, the tribunal found that the father's name is not matching, but this is not correct. This is absolutely, my lord, perverse finding.
Here it is.
Name is exactly similar, my lord.
Exactly same or similar.
Exactly same, my lord. Amuruddin.
Amuruddin.
And my lord,
Here is Amiruddin.
yes, my lord. Notice is also Amuruddin.
Amar would mean one who never dies. Amir would be somebody who is very rich. So it's a lot of difference. One word, one letter, but lot of difference.
One who is rich never dies.
And the suggestion of my brother is very good. One who is rich never dies. Very beautifully said.
This exhibit 8,
My
there's a
lord.
discrepancy, I think, in terms of the date
Exhibit,
that your brothers ordered.
yes,
Is it 25/6/15 or 25/5/15?
25. My lord, there may be a mistake, my lord. 25/6/2015.
But in the order, it is reflected as 25/5. So perhaps
My lord,
the
that-
same order.
Yes, my lord. 25/5. That is also wrongly recorded in page 1, page 46.
Yes, some
25/5/2015 is wrongly recorded. Maybe this type of mistake may be, my lord, bona fide mistake, my lord. But judgment.
No, mistakes are not bona fide. It may be clerical error.
Yes, my lord.
Bona fide mistake.
Clerical mistake. Yes, my lord. Bona fide clerical mistake, my lord.
Clerical mistake.
The father's name is matching, but tribunal appreciated showing that not matching. This is
Shows the document because
my lord.
this is something we could not do.
Lordship, kindly have a look at the notice passed at page 19. I want to show my lord the notice because here father's name is Amaruddin. And the brutalist of 66 also Amaruddin. And the brother's judgment is also Amaruddin.
Okay.
And one point is in the notice. That is my legal point. So for the full bench judgment, there is no ground of suspect in the notice. Simply, my lord, whereas in terms of the foreigners or tribunal order 1964, the superintendent of police Bongaigaon Sirang has referred a case before the foreigners tribunal for opinion, suspecting your family members as foreigner entered into Assam from East Pakistan, Bangladesh under the Foreigners Act 1946. This is a mere suspect. This is not the, my lord, the main grounds. The full bench judgment in para 124 has clearly, my lord, said that main ground should be given while serving the notice. Where is the main grounds, my lord? Only on mere suspect. My lord, this is my technical point, my lord, legal point. And this has been taken in filing the WS. WS is not proper, my lord, but this point is taken in the WS. My lord, this is my submission on the technicality, my lord, and kindly have a look at the voter list of 1966, page 26. My father's name recorded is Amaruddin. Mother's name Ivan Bibi. Then, my lord, voter list of 70. Village is same all along Tantonpur. Amaruddin, 70 voter list, Ivan Bibi, my mother's name. Then, my lord, in 97 voter list, Sher Muhammad Amaruddin, village is same Tantonpur, my lord. Then, my lord, voter list of 2011, Sher Muhammad Amaruddin. Then, my lord, land documents, my lord, annual periodic Kiras Patta. My father's name here is little variation, Amiruddin instead of Amaruddin. And my brother's name, my lord, Nur Islam, who is declared not foreignized, his name is also there along with the other brothers. And one documents, my lord, was produced 1985 voter list. My lord, it was submitted after filing of the, I think, my lord, after filing of the WS, but by way of petition. Petition was allowed. The petitioner was allowed to produce the voter list of 1995, but not discussed in this judgment. There is an order on to that effect, my lord. The order dated that was my lord, order dated 26/2026.
Where is that?
My lord, lordship will find it in record. There is an order dated 20/20/2016.
2020.
20 February 2016.
What does it say?
My lord, OP is present. OP has already filed evidence in affidavit. Next date is fixed for argument. And there is another order My lord, on 23, 2015.
20.
Yes, my lord. February, 20 February, 20 March 2015. That
Yes.
is in a record, page 40 of the record. He moved a petition on that day, praying for producing further document. He was allowed.
Okay.
That is a voter list of 1985. But original of that voter list is also in the record without any exhibit mark. My lord.
Okay. And so
And
what?
that was not been discussed at all.
It's okay, but what does it favor you? How does it favor?
My
you?
name is with my father.
Oh,
My mother is also there. There may be some name variation, but my name with my father and my mother. My brothers also there.
brother, which brother?
My lord, I have no copy, my lord.
No, it's okay.
My father's name is, my mother's name is there, Ivan Nessa. My father's is also there.
Okay.
That has not been discussed.
Mr. Pang, please check that. Exhibit of voter list of 1985.
85.
Please,
Yes.
please
In page 40.
page 40.
Page 40 and original copy is at page 65. Page 65, sir. Original
This is
copy.
not enclosed to the petition.
Not enclosed to the petition. My lord, I discovered by going through the records, my lord. Party has also not instructed me about this.
In fact, we would appreciate your endeavor to look at the record and assess the court.
It is a
Obliged.
record. 85 voter is list in record, but no exhibition.
Not exhibit.
Not exhibit mark. That is that. But there was a petition. He was allowed to produce that.
Allowed to produce. Petition is.
There is an order, my lord, at page 40. That petition is at page 40
Petition
in the
is
record.
Just find out what is the name of the brother whose name is there in 85. What is the name of that brother? 1985 voter list. What is the name of the brother? Which brother is there in fact?
Voters are 85 voters are Amiruddin Sheikh, number one. Amiruddin son of Afiruddin Sheikh. Then Auban Nessa,
Ivan Nessa.
Auban, AWBAN, Auban Nessa, Amaruddin Sheikh. Then Iman Ali, my lord. Iman Ali,
One brother.
Iman Ali.
yes, son of Amaruddin Sheikh.
Uh,
Amaruddin Sheikh. Sher Ali, son of Amaruddin Sheikh.
Sher Ali.
Sher Ali. Zohira Khatun, relation Iman Ali. These are two.
So one brother is there.
No, but
Who
then
is Sher Ali?
Sher Ali is the petitioner, my lord. Sher Muhammad, Sher Ali, my lord. That is the
but
variation.
then again, you see, even if you prove that, let us assume that you have proved this document, but still it doesn't help you. Come to page 32.
Iman Ali is there, my lord.
Only one name. Others
My-
are not there.
Other brothers, my lord, I think, my lord, the brothers, other brothers are not eligible to be voter, my lord, therefore not, their name is not there. But Iman Ali is there, elder brother Iman Ali is there. Nur Islam and Nur Muhammad, they are not there.
But they are not there.
Sher Muhammad, my lord, is
They are
there.
not there in the voter list.
My lord, 85 voter list, they are not there. But I have annexed one voter list of 2016 in the writ petition, my lord, where the Iman Ali, Nur Islam, they are there.
Okay, anything else?
My lord, one important point, my lord. I filed my evidence in SIT, but I was never cross-examined.
No cross-examination.
No cross-examination. So my claim, my lord, based on 6670 voter list of my parental identity is not at all denied, my lord. Question of rebuttal evidence does not arise, my lord.
Where is your voter list of 1966? Which page?
1966, lordship will find in page 26.
26. But then you don't succeed in this case.
My lord.
But in this case, you don't succeed. We'll show you why. Come to page 42.
My lord.
Your typed copy. In the middle, the second, the first, second, third paragraph, fourth paragraph.
My lord.
The learned counsel for prosecution side. You got it?
My lord.
Now you come to, after 3 lines,
My
the
lord.
exhibit core is the voter list of 1966, where OP's father's name has been recorded at voter, at number 42, Abhyapuri, Abhyapuri SC,
Same
house
serial
number
number.
11.
Same serial number, house number, my lord.
Serial number 23, house number 11.
My
Both
lord.
sides matches.
Same serial number.
Okay, okay. 42 matches.
That is the, my lord, that voter list also used by my brother in his case.
Same voter list.
My lord.
Okay, okay. Okay. So this matches. What is the opinion of the tribunal with regard to this? Your
My lord, first thing, my lord, 85 voter list not at all discussed, my lord. Maybe could have
Where's
been
the opinion?
rejected, but not discussed at all. Then, my lord, lordship may kindly have a look at the paragraph, page 47. The relevant portion is there. Here, my lord, from the third paragraph, from the record, it appears that the OP has projected Amuruddin, son of Fakhruddin, as his father, whose name appeared in Exhibit 1 and Exhibit 2. In Exhibit 3, OP's name appeared as Sher Ali. My lord, Exhibit 3 is the voter list of 1997. My name is not in that voter list as Sher Ali. My in 97 voter list, my name is recorded there as Sher Muhammad. That is a wrong appreciation. Son of Amuruddin, and his father's name appeared as Amaruddin, son of Afruddin. In Exhibit 3, my grandfather's name is.
Please take us to the document. Which document? Page number?
My lord.
You're showing us which document?
My lord, I'm referring my lord 97 voter list.
Where is that page?
Page 28, my lord.
28.
My Lalet Tribunal has said that in 1997 voter list, my name is written as Sher Ali. That is not. My name is admittedly written in 85 voter list as Sher Ali, but not in 97 voter list. Tribunal is discussing my lord, Exhibit 3. Exhibit 3.
Exhibit 3 is 97 voter list.
Yes, my lord.
Okay.
And my lord, tribunal also, my lord, discussed, my lord, Exhibit 4, OP's name appeared as Sher Muhammad with his family members. Exhibit 5, OP's name appeared with Harisaran Das and some other person. All are shown as son of, my lord, in page 47. I am reading this, my lord, judgment of the tribunal.
No. When you are reading this, take us to that document also.
Yes, my lord. Exhibit
this
4.
Exhibit Amaruddin, son of Afruddin.
Yes, my lord.
Where is that?
Exhibit 4, my lord. Exhibit.
No. OP's name is appeared as Sher Ali.
Yes, my lord.
Son of so and so, and his father's name appeared as Amaruddin.
Afruddin.
Son of Afruddin. Where is that?
My lord, my lord, tribunal is discussing about Exhibit 3. So, my lord, Exhibit 3 is the 97 voter list. 97 voter list, there is no such recording, my lord.
Amaruddin is not there.
No, my lord. It is Amaruddin is there against my name.
No, but
Amaruddin name is not in the main column. So,
okay. Now, this Exhibit 4 is.
Exhibit 4.
Where is
my
the
lord,
document?
Exhibit 4 is the voter list of 2011. Lordship may kindly look at the 2011 voter list at page 29.
This is Exhibit 4.
Exhibit 4. Here, my lord, in Exhibit 4, OP's name appeared as Sher Muhammad with his family members. Yes, my wife with me, my lord, Sher Muhammad and Monora Begum. Exhibit 5, OP's name appeared with Harisaran Das. That is the, my lord, land document. Annexure 7, page 30. All are shown as son of Amuruddin, but their names are not appeared with OP or his projected father in any of the other exhibited documents.
Exhibit 5, OP's name appeared with Haricharan Das.
Yes, my lord.
Where is Exhibit 5? Page?
Exhibit, my lord, at page 30.
30.
Page 30 is the translated copy, vernacular at page 32, my lord.
Haricharan Das is not there.
Haricharan Das is, my lord, in the main content, my lord, in the middle of the content. My lord, the petitioner and his brother's name and along with one Haricharan Das were given in periodic patta. That is the order of the deputy commissioner.
Oh, achha.
Well, tribunal has picked up the point that why the petitioner's brothers are not the person who are mentioned in the exhibit, this exhibit, why not with the brothers? But I have in the voter list of 1985, my lord, one brother is there. Maybe, my lord, the other brothers were not eligible to be, they have not attained the age of majority for entry in the voter list. Therefore, may not be in the voter list of 1985. But I have annexed one 2016 voter list, vernacular. The other brothers are there. The Iman Ali, Nur Islam is also there. Then, my lord, exhibit
my lord, from exhibit 5, it cannot be ascertained whether it is self-acquired property or inherited from their father. Exhibit 8 is the opinion passed in BNGN FT case number so-and-so, Bongaigaon, on 25/5/2015 against one Nur Islam alias Nur Islam Sheikh. In the said opinion, Nur Islam is shown as one Amiruddin. That is my lord, I have already mentioned, my lord. In the brother's case, my lord, father's name is found as Amiruddin. That is wrong, my lord. Father's name is also as Amuruddin in the judgment. In the said opinion, Nur Islam is shown as son of one Amiruddin, and OP stated that Nur Islam's name appeared in exhibit 6 with the OP. By the said exhibit, by the aforesaid exhibits, it cannot be ascertained that Amiruddin, who is shown as father of Nur Islam and father of the present OP, is same as Amiruddin, whose name appeared in exhibit 1 and 2, because by exhibit 7, it cannot be ascertained who is the father of Amiruddin. My lord, this is absolutely wrong discussion, my lord. Yes.
Mr. Payen, page 32, the then document. What is the connotation of the inscription there in the vernacular.
Yes. May I read?
Yes.
Just we tell you. In this column, then before that column part. So,
Yes,
that column part, there is a box
yes,
in that page 32,
yes.
right? Just before the box, in 2 lines, you'll find the same words. Thola Bihikto. What is the meaning of that word? Can you tell us? Both lines you'll find the same word.
Last 2 lines
Last 2
above
lines.
the column.
Above the box.
Yes, ma'am. আপোনাৰ উত্তৰাধিকাৰী প্ৰতিনিধি আৰু স্থলাভিষিক্ত
What does
বিলাকেৰে
this word mean?
replaced. Replaced. huh? Replaced. It will be replaced.
Is it successors?
No, my lord.
Placement of Sthala.
It will be like replacement, in
Transfer.
place,
When this, our Sthala.
in place.
Transfer. Transfer.
Yes, ma'am, but because the other is Uttaraধিকাৰী প্ৰতিনিধি
আপোনাৰ
or
উত্তৰাধিকাৰী
স্থলাভিষিক্ত
প্ৰতিনিধি আৰু
বিলাকে. স্থলাভিষিক্ত it means like transfer, your honor, that means from one person it is transferred to another.
Okay, transfer.
This clearly indicates that the families occupying the lands since long back and they
Since
are.
long back, we don't know. There can't be a presumption of since long back.
From 2004.
This is from 2004.
The patta is from 2004
Yes, my lord.
for 20 years.
Yes, 2004. Because this has been, this also indicates that the land has been possessing earlier, therefore they are.
No,
That we don't know.
that we don't know. We can't presume.
That will be available in the records
My lord.
connected to this particular
My-
document.
But we can't presume.
My lord. But the brothers name are there, they are the smaller son of Ambaruddin.
Yes, Mr. Payang, what do you have to say?
First of all, my lord, what I have seen, though the learned tribunal has, my lord, discussed about the opinion of his projected brother, that was never exhibited. I have seen the record. The document is there, but when it is exhibited, how it has come to the record, no order is there.
No, no.
Yes.
Please confirm the record.
Brothers. My lord, judgment is exhibited by exhibit number and is also on the record, my lord.
It is
And
in
has been
record.
discussed also.
It is in record. It is.
It has been discussed also.
But
And the
No, just a moment.
discussing, my lord, and showing variation of father's name
No, just a moment.
discarded, my lord.
Just a moment.
the last piece, my lord, it is the opinion of the projected brother, my lord. The transfer.
In page 83 of the record, my lord, the judgment is there.
No, we are concerned with that new document which has come. Where is that page?
My lord, the judgment,
No, new document which you said that
My
you
lord.
called for.
865.
65.
Yes, 85 brutalist. There is an order of allowing to produce the records. That is, my lord, that page 40, the petition. At page 40, the petition.
Page 40.
Yes, my lord. Petition dated 28th March 2015. Praying for producing further documents. Prayer allowed by order dated 20th March 2015.
Please come, order dated
My lord, order dated
23/2016.
23/2015.
No, there's no order of 23/16. It is 33/16. 22/16, there is an order.
22.
OP is present, OP is already filed evidence on affidavit. Next date is fixed for argument.
My lord.
Then the
My
next
lord,
date
there is, I have seen, my lord, there is order dated 23/2015. On the same day, he has filed petition, and on the petition, there is an order. My lord.
23/2015.
Yes, my lord. Petition is at page 40.
Oh, no, then we cannot help you there with 1985. Now we will tell you the reason.
My lord. My lord.
It's not very difficult once you look at the sequence. You see, on 23/2015, you file an application to bring the document on record. It was allowed.
My lord.
Then there is another order of 3/2/2015. 3/2/2015 says CR put up today, OP is present with advocate and file evidence on affidavit. That means the document was there, but you did not exhibit it. Your petition was allowed, and this is supported by document at page 41 of LCR, which is a which is a Firisti filed on 23/2015 with the document.
My lord. Documents, original voter list is there, my lord.
It is there, but you did not, in your evidence,
My
you
lord.
discarded that.
My lord. There is a judgment, my lord. I am with the judgment, my lord, of this honorable court.
No, but you see,
When a certified copy is produced without any exhibit mark, this honorable court has held that that should be accepted. If the party has not marked it, court should accept it as by using a mark. There is a judgment, my lord.
to us that, but that can't be.
My lord.
That
Yes, my
cannot
lord.
be. That is the, then we'll have to, okay, you show us the judgment,
My
we'll
lord.
take care, we'll examine that, but today we'll have to rise. There's a,
My lord.
my the bench has to break. My brother has a single bench.
And my point, actually, my lord, the learned tribunal has come to a conclusion that in the judgment of brother and the voter list are not matching. Amiruddin and Amaruddin. That is absolutely, my lord, perverse finding, my lord. Paragraph 10, my lord. Paragraph 10. Referring a judgment.
Just a moment.
My lord. Sorry, my lord. Paragraph 17.
Yes, paragraph
17, my lord. In the present case, the documents are on record.
Just a moment, just a moment. No, I'm sorry. I'll tell you now what is this there in the judgment. In this judgment, the court was considering the provision of CPC where it says that a document should be filed to be exhibited before the settlement of issues. And then there's an exception carved out. It says that there is also a provision under which application can be made for admission of documents which are subsequent to the settlement of issues. That you will find if you read this paragraph 2, 3, 4 and 5, there you'll find the sequence why this has come. Then what has happened? In this case, the High Court was in session of an appeal. In appeal, there are provisions for the appellate court to take up the documents in appeal. Now, this will find in paragraph 1 of the judgment. This is an appeal. Correct. Now, you will find in paragraph 13 about the documents and the framing of issues. Correct. Now come to paragraph 16. Paragraph 16 says the next question which arises for consideration is whether the principle will be applicable to documents which are filed with permission of the court after settlement of the issues. Order 13.2 provides that no document evidence of so and so. Correct. Now it is said paragraph 17. The present case documents are on record and have not been returned. The documents are certified copies of public documents and therefore documents are not required to be proved by calling witness. However, the documents are not considered by the court below as the documents are not marked as evidence. Therefore, the document shall be marked or numbered as so and so respectively. Therefore, appellate court is exercising power to admit this into evidence. But with all respect, I would disagree with this proposition, but this is contrary to the principle which is already settled by this court as well as the Supreme Court of India, where the appellate court power to admit documents is circumscribed by the provisions of Order 41 Rule 27, which says that this document cannot be taken into consideration by an appellate court without complying with the reason. And after that, Ibrahimuddin and all, it has been settled that the document can be admitted only on 3 conditions. Those conditions are laid down. So it's a judgment of the Supreme Court, and therefore this judgment of AIR 1990 Guwahati 7, with all respect, may not be the good law after the Supreme Court's decision.
My lord, a part of this,
We'll take it up some other day because today we really don't have time. But you see the law in this.
my lord,
The additional evidence which has been laid down by the Supreme Court in judgment 2013 or 14, I forgot.
my lord,
Ibrahimuddin.
there are decision of Supreme Court and this honorable court that strict rule of evidence are not to be applied in
That
the
is
case of
something else,
evidence.
but you are laying us before a proposition which is dependent on the fact whether an appellate document is admitted, and therefore we had to read the entire document.
My lord,
The only bad part is I can read fast. All sides are represented. Due to positive time, the matter could not be heard. So based on this one, Friday. Done. Make it Thursday, date, just see the date.
12.
12th. We are listing it on 12th.
my lord.